Well, let's talk now to an expert who's going to try and explain all this. Professor Anthony Glees. Welcome to the show, Anthony.
Good morning, Kevin.
First of all, I'm just going to play a quick clip about all this from the Shadow Home Secretary, Chris Philp.
In my opinion, China poses an active and current threat to the United Kingdom. That is all the government needed to say to the Crown Prosecution Service in order to secure this conviction, and yet they did not.
Well, that pretty much sums up the problem here, Anthony. And right now, they'll be beginning to give their case to the Joint Committee. That is Darren Jones and Lord Richard Hermer. And the government's case is that they had nothing to do with the collapsing of this spy trial. Two alleged spies feeding information to China. They said it's nothing to do with us. And it wasn't that the government decided or told the Crown Prosecution Service that we could not classify, in this case, China to be an enemy of this state. They're going to say that that wasn't the case. They are now, Labour, refusing to publish the files on this, the China spy files. It gets murkier by the day, doesn't it, Anthony?
Well, it does. I mean, they're making an absolute horlicks of what should have been an entirely straightforward matter. There's been the legal argument here, and I think people understand that, and then there's been the political argument. So the legal argument is that these alleged offences, which the two gentlemen deny committing, the alleged offences took place before the replacement of the 1911 Official Secrets Act by the July 2023 National Security Act. So you have to charge them, we all understand that, under the 1911 Official Secrets Act. But actually, if you look at the 1911 Official Secrets Act, it is broader in scope than the 23 Act, and it certainly would allow these men to be charged and, in my view, lightly convicted for spying for China. And let me just quickly read you the words of the 1911 Act, which says that any note calculated to be or intended to be directly or indirectly useful to an enemy falls foul of the Act. So people writing reports about secret things passed to the Chinese automatically qualify. That is why the Director of Public Prosecutions originally agreed to charge these people. And you may say, oh, an enemy. What's an enemy? Is an enemy somebody we're at war with? No, 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 no. The first conviction, successful conviction under the 1911 Act came the next year when a German spy called Grosser was convicted. That is 2 years before Britain was at war with Germany. So enemy means somebody who threatens our security. And I'm not going to bore you by reading out a list of very significant figures, former national security advisors, leading spooks and so on, who've all said China
is an enemy. But so what you just read out, Anthony, that's at the heart of the matter, isn't it? In order to successfully prosecute anybody for breaking our Official Secrets Act, we must classify the people they're selling secrets to as an enemy, and that is what our government has refused to do. Can we have a quick listen and watch of the former Attorney General, the booming voice Geoffrey Cox, criticising the government on this case? Check it out.
But if it walks like a duck, quacks like a duck, sounds like a duck, looks like a duck, it's almost certainly a duck. And the problem in this case is that the government was never prepared to describe that animal as a duck. And it must have known from a very early period. Indeed, the first senior Treasury Counsel said yesterday that even in August he had made this point abundantly plain to the government that unless it reconsidered its approach and described the blasted animal as a duck, the case would go down the pan.
I want a voice like that, Anthony, but he makes the point brilliantly, doesn't he?
Well, he does, but it is also true that the previous Conservative government, and indeed governments from Boris Johnson down, always refused to say China was an enemy, under the mistaken belief that in law an enemy is a country we are at war with. But that's not true. An enemy is a country that means to do us harm, that subverts us, that spies on us. That has been our definition of an enemy since 1911. So we had the wherewithal. And the second thing, Kevin, that is now being said that is equally balmy is that, yes, China may be a national security threat. We heard the former head, a very clever chap, former head of MI6, Sir Alex Younger, say this yesterday. China may be a national security threat, is a national security threat, but we can manage that threat. But we can't manage the threat if we cannot put two people suspected of spying for China before an English jury. If that is prevented, we cannot challenge China. So whether it's this government or the previous government and previous governments, the idea that we can do business with China, let them build this huge super embassy at Royal Mint Court, which the Chinese have bought. That's also most extraordinary. Most countries do not buy their embassies, including the United States. They get them on a lease, not China. 255 million quid for this, their super embassy, because we are fiddling about with what is an enemy. It's blindingly obvious to everybody that China has a hostile intention. And during the Cold War, we put lots of Soviet spies on trial. They were convicted. We weren't at war with the Soviet Union. Now, the government is talking complete nonsense, but so is the Director of Public Prosecutions. Heads, Kevin, must roll.
Yeah, no, Anthony, you know what happens in these situations. It's so grave that deputy heads will roll. Anthony, really, really good to talk to you. Thank you so much for that. That's Professor Anthony Glees putting it all into perspective. Let's have a